Welcome to podcast 2 from me, John Fotherby.
And me, Alex Johnson.
And in today's podcast, we're going to be talking about delay and time extension. And I think that this is an important issue for employers, owners, contractors, subcontractors. And it probably causes some of the greatest discussion and argument between the parties. And again, we mentioned in our last podcast the different perceptions that the parties have of the contracting situation, and in this case, the time. And I think that from the owner-employer's perspective, the problem is that when there's a delay, the employer doesn't receive the plant that he's actually paying for on the date that he expected and was able to put it into use. And it doesn't matter whether it's a plant or whether it's services or whatever it is, he's not getting the product. But from the contractor's perspective, it's taking longer, it's costing more money, and it's consuming resources over a longer period than expected that could otherwise be used probably on other business. So right from the start, we have this dichotomy between the parties and their interests in time. So, Alex, let's look at that from a legal point of view then. What have the parties agreed to and what are the implications?
Yeah, thanks, John. I mean, typically, the construction contractual position on time is actually fairly straightforward. All construction contracts will contain a target time for completion, which sometimes is referred to as the contractual completion date. And that's an obligation on the contractor to complete the work by that particular date. And that date is usually written into the contractual particulars somewhere. There will be an obligation on the contractor to proceed with the works with due diligence and in accordance with the contract to achieve completion of the works by that particular date for completion, and then consequences for what happens if the contractor fails to do that. And typically, the reasons why a contractor will fail to achieve the time for completion are either things that the contractor has caused to happen. So if they don't have enough labor, or there are delays in material deliveries reaching the site, there will be events that the employer or owner causes to happen. So, for example, the owner somehow prevents the contractor from accessing the site or fails to respond to requests for approvals in a timely manner or in accordance with the contract. And then there are the sort of final category of neutral events, which are neither party's fault, sometimes referred to as force majeure, or in the FIDIC contracts, exceptional circumstances. And those cover things like adverse weather conditions that are unusual, strikes or lockouts among the workforce, natural disasters, all those types of things. So a whole host of issues can cause delay to a construction project. And the way that a construction engineering contract will deal with those is to define what the events are and apportion them on one side or the other. They're either the contractor's risk or they are the employer's risk. And the events that the employer causes, such as prevention, are obviously the employer's risk. And so the contractor will be entitled to extension of time if the employer prevents the contractor from proceeding with the work. And also usually a smattering of neutral events will also entitle the contractor to extension of time. And those events are sometimes called relevant events or delay events. And then usually everything else is the contractor's fault. So if it's not one of those defined events, then it's the contractor's delay, and that is called culpable delay. The other thing just to mention, which will be in an upcoming podcast, is liquidated damages. So if the contractor fails to complete the work by the contractual date for completion and is not given extension of time, then usually he will be obliged to pay liquidated damages to the owner.
So, Alex, you've talked about these different events. How does the contract deal with the mechanics of the employer granting an extension of time? What does the contract need to contain to enable that to happen?
Well, usually there's some kind of formal procedure, which is basically summarized as the contractor has to give a notice to the owner of a delay, usually when it's occurred. Some contracts will say, or when the contractor should have become aware that it had occurred, some typically legal wording like that. And so the first port of call is really contractor serves a notice in accordance with the contract. If it says serve the notice within 15 days of becoming aware of the event, then the contractor has to do so. And usually the contractor will have to state the time extension that it thinks is due as a result of that issue. And one thing to note there is that this is all while the project is happening. So at the point the delay event occurs, it might well be unclear to the contractor what the full consequence of it could be. And so some contracts, FIDIC, for example, has a procedure where if a claim is ongoing, then further notices will be given to update the claim as it continues. And generally, as long as the contractor has fulfilled those, what we call conditions precedent, if they're expressed that way, which typically they tend to be, then it falls to whoever is the contract administrator, so an engineer in the FIDIC contract, for example, to fairly and reasonably assess the extension of time that the contractor is due. And if they consider that an extension of time is due, then the effect of that is to refix the date for completion. So if it was originally the 1st of January written into the contract and the assessor thinks that the contractor is entitled to 2 months extension of time, then it will be refixed to the 1st of March.
And going back to these conditions precedent, if you see in the contract that it lists all the reasons for extension of time, owners' breaches and force majeure and all these things, and it says an extension of time will be therefore awarded, always provided that the contractor has given notice in accordance with the contract and has taken measures to mitigate. Those are conditions precedent, are they, to what you mean to award an extension of time?
Yeah, in the formulation of wording that you just mentioned, so that provided always that type wording suggests to me that's a condition precedent. And if those conditions aren't fulfilled, then the English courts have been fairly strict about saying, well, you can't have the extension of time, even in circumstances where the employer has caused the extension of time. So if the employer has prevented the contractor, but the contractor has failed to submit the notice as required by the contract, and that's a condition precedent, the courts have said no extension of time. Equally, where the criteria is not a condition precedent or is expressed a bit more vaguely, then the courts have had some sympathy with saying that those are not conditions precedent, and so it was not fatal to the claim that the contractor failed to submit the notice on time, for example.
Okay. Now, in that context, I've read in a number of international contracts now that as part of those conditions precedent, that it says, and provided that there is not a contractor delay that is concurrent with the owner's delay. So what's your view on that then? What does that mean?
Current delay is the perennial topic that comes up, which I'm going to summarize I think, in a quite simple way. I think people get very excited about concurrent delay and very worked up over it. But actually, what it means is where you have a project overrun that is essentially caused by two or more causes of a delay, which are, and here's some legal text for you, approximately equal causative potency, which I'll just leave hanging there.
Could you say that in English, please?
Essentially, they're both equally serious as each other.
All right.
And so where you have a culpable delay, i.e. contractor caused it, that occurs at the same time as an event that entitles the contractor to extension of time, that is true concurrency. But I have to say, true concurrency is extremely rare. and all of the delay experts that I ever speak to say, well, basically it doesn't happen because there is always a possibility to attribute the delay to either one cause rather than the other. So concurrent delay, we all get very excited about it, but actually it never really happens in practice. But should it happen, should it be one of those unique situations where there is actually some true concurrency, then the English law says that the contractor will receive the benefit of the extension of time, and there's no ability under the English law to apportion the delay either to one party or the other. So that case is Henry Boot and Malmaison. Note though, the test is different for money. So when it comes to additional payment that may arise from the event, that comes down to causation. So that comes down to the but-for test. And so even if on the time side of things, the concurrent delay results in an extension of time for the contractor, it is unlikely to be the same position when it comes to the money, because the legal tests for those things are different. But
that's
yes,
what we're going to address in a subsequent
we'll talk about that
podcast as well.
subsequently. But essentially, concurrent delay, everyone gets excited about it. Contractor benefits if it does happen, unless, of course, the contract says something different. It's open to parties to say that the employer will receive the benefit of a concurrent delay, and often you see that. But if the contract doesn't say anything about it, then it will benefit the contractor if indeed it ever happens.
Yeah. And when we're talking about extension of time, we're talking about events that are on the critical path.
Yes.
At the time of the delay, right? That's my understanding.
Absolutely.
Am I right?
That's right. Yeah. So it has to be a delay to the ultimate completion date.
Yeah. So we draw a distinction then between delay, which is pushing out the completion date as you've just described it, and lateness, which means there is an activity that's completed later than the schedule indicates, but isn't impacting the completion date. Is that also correct?
Yeah, that's right. So you draw a distinction between critical and non-critical delay. An extension of time requires critical delay. Simply doing something late that doesn't impact on the contractual date for completion, on the target date, doesn't result in extension of time. But you can have a series of those delay events that add up to the point that they do become critical, and then they do potentially result in extension of time.
Yeah, and that then is just the erosion of float on those activities then.
Yeah.
That means they then become critical. My understanding from a lot of the schedules is that I've looked at, and I'm not a delay analyst, I have to confess, is that there's about 20% of any standard typical schedule that's on the critical path. And the remaining 80% are not critical and therefore are subject to being late until they erode all the float and become then critical. So a lot of analysis with time extension seems to focus on, not surprisingly, the critical path. But in your experience, is it as well to look at the entire schedule and to see what the effect is of the events that are causing activities to run late, to see how the float is being eroded? What's your view on that?
The answer is it very much depends. And the reason it generally depends is because schedule delay analysis costs a lot of money. And so what I've seen, for example, on some of the biggest projects that I've looked at, so you're talking about extremely large infrastructure projects, it is just simply not practical to review the entire schedule. Not only because the schedule was very unrealistic to begin with, that it hasn't been updated in the proper way, that it is frankly useless at the point that the delay really occurs. What actually happens on those type of disputes is parties would generally focus in on the events that have caused the delay in the most significant way and work out the impact on the schedule of those events and use a sort of Windows type approach. Now, there will be other projects that are not of that scale where, yes, it's entirely appropriate to consider the whole schedule. But you do have to draw that distinction between what the delay analyst is looking for, which is the extension of time to the date for completion, critical delay, and as you say, John, the lateness, which is a lot more difficult to identify. Anyone who's not a delay expert, or anyone who doesn't know anything about scheduling, such as lawyers, will look at a schedule and think, "Wow, what's that all about?" So we are reliant on these experts to unpick exactly what is happening there, and then they will turn it over to us lawyers to identify who we think is responsible. So in a long-winded way of trying to answer your question, it really depends on the dispute, on the project, on the budget, on how much is at stake. If you're only claiming a minimal extension of time and a minimal amount of prolongation cost, there really isn't a lot of point in spending a lot of money on full delay analysis. So there are many things that go into the equation of what parties have to look for when it comes to identifying the loss.
And again, that's going to be the subject of a separate podcast.
Yeah.
Is how do we get to the large amounts of money? I have another question. Time at large. What does that mean?
Means different things to different people in my experience, but I'll tell you what I think. So fairly simply, we said right at the beginning, the contract has to contain a date for completion, and it has to deal with what happens if the date for completion is not met, one way or another. Now, when some of that machinery breaks down, we might be talking about time at large. So the classic example is an example of a case I have at this very moment, is if there's no extension of time clause. Now, the reason in my particular case is that the project is an EPC project in the Middle East, but the contract is not for EPC projects at all. It's for something else. And so it doesn't contain all of the usual machinery we would expect to see in such complicated EPC projects. So there's no extension of time clause. Therefore, what has happened, we may as well take this project as an example. The employer committed many acts of prevention against the contractor. So denying access to the site at certain times was a big example. So what's the effect on the completion date, which had a defined particular date? Well, the answer is because the employer is preventing the contractor from carrying out the work, the employer cannot benefit from its own breach of contract. So it couldn't say to the contractor, you are still required to complete by the original date, and I'm still going to have my liquidated damages if you're late. What actually happens is, due to the prevention, and this is called the prevention principle, the obligation on the contractor to complete the work by the agreed date is actually replaced by an obligation to complete the work within a reasonable time instead. And what is reasonable depends on all of the circumstances. It also has the effect that liquidated damages are unenforceable. And it's in this situation that time is said to be at large. And it means that the original date has disappeared for some reason, and the contractor is obliged to complete the work in a reasonable time instead.
Okay. I'm looking at one or two contracts like that at the moment, where they link the rights to damages if the contractor is late, but don't actually provide any mechanism for dealing with the delay, whether that's under civil code contracts or under common law contracts. So really, the extension, from what you've explained, the extension of time clause is really of benefit to both parties, because from the owner's point of view, it seems that it keeps his, as long as he deals with the delay and the extension of time for which he's liable, that keeps his rights to liquidated damages alive in the event that the contractor doesn't complete by the extended date. And from the contractor's point of view, for the delays that the employer causes, he doesn't pay liquidated damages because there's a new completion date. That, in summary, seems to be about where we are. And if we don't have that situation, then there's a possibility that we have time at large and the whole set of new rules apply that you've just described.
Yeah, that's right. And the other benefit to the contractor is to save it from a claim for general damages, for failure to complete by the completion date. But yes, you're right. It does. It kind of puts you kind of go off the base of the contract. I think when time becomes at large, the contract is really put aside from a time perspective.
Yeah.
And the discussions that the parties have had on the example that I've given, I mean, funny enough, both accept that time is at large, so that's not in dispute. But they are having real discussions about, well, so when are we supposed to complete the work? And of course, the only answer that the law gives is, well, within a reasonable time. What's reasonable? Well, how much work is left to do? Well, how long will it take? So this is it's very unsatisfying in that sense. But legally, it's a solution of sorts, I suppose.
I guess we come back then to where we started, which is the difference in perception between the owner's view on how much work and how much time and the contractor's view on how much work and how much time.
Yes, absolutely.
And hence the need to keep the integrity of the contract together as far as time is concerned from a management point of view. Otherwise, you're into an era of great uncertainty as to when you're going to finish your contractual obligations.
Yes, that's absolutely right.
So we don't want to get into dispute as owners or contractors or subcontractors. Ideally, it's not a fun experience, and as you mentioned in the first podcast, it can be enormously expensive. So if you are in arbitration because it's all broken down, from a lawyer's point of view, what do you need to be able to establish entitlement to an extension of time? What's the basics that you will be looking for from one of your clients, a contractor client, for the sake of argument?
Yeah, sure. I mean, the basis really for this claim or for any claim is we need to see the records. So the starting position is what happened, which sounds easy, but actually is a very difficult question to answer, and in itself requires a lot of investigation because you will generally have the view of the project people on an event that may have happened a while ago. Memory is not always trustworthy. There are generally certain prejudices that those people will have, and so I usually take what the client tells me with a little bit of a pinch of salt until I've seen the records that support what they're saying. So there is records on the fact of what happened, and that's usually formed by the project record correspondence, emails, letters, reports. Could be pictures, video, depends on the issue. We also need to see progress reporting, schedules. And once we have a level of understanding on the facts of what happened and the client's view on what that caused, most of the time you will need some form of delay analysis to work out what the delay was and how long it was. And then the final legal task is to work out who caused it, who was at fault. So usually there is a combination of factual investigation by lawyers, delay analysis either by the client's in-house people if they are all over it. Some are. Sometimes with a scheduled delay expert. It's not an absolute in these claims. Delay is a factual inquiry. So if you have the best records in the world, you probably don't need a scheduled delay expert because it's plainly obvious what happened. But I live in the real world where these things are not usually like that. So what we generally need from our clients is an understanding of the records they have, how good they are, what they show, and then there is a decision to make once we understand the facts about whether we turn it over to a scheduled delay expert to work out the critical path and the delay to the critical path.
Right. So it's really, we need a schedule that we committed to, the regular updates to that, the progress reports, and I guess also like execution plans, because the time schedule just shows you how many activities and how long, but the execution plan of how we were going to do it, particularly with more complex projects, big EPC projects.
Yes. Yeah.
And
If
what
they
about
exist.
manpower loading and things like that? You need to see those as well, I guess, and what was planned and what actually occurred.
Yeah, all of those records are
Yeah.
all very important, and manpower loading probably more so to the money side of it than the delay side of it. But yes, project execution plans can be very useful documents as well, particularly where they're contractual documents.
Yeah.
But the documents I usually find most interesting and revealing tend to be the progress reports, because they are explaining what was happening as the project
Yes.
was going along.
Yeah.
Although, some reports are better than others. Some are 200 pages every month. Some are a side of A4 every month. So it can depend on what level of reporting was going on. And I'm not saying the bigger is the better either. It can often be the case that you can have a 200-page report that doesn't explain an awful lot. Equally, you can have a very short report that very concisely explains what was happening.
Yeah. So we started this podcast by you saying this question of delay and time extension from a legal point of view is really quite simple and straightforward. What we've just discussed does not seem very simple and straightforward. It really does depend on the circumstances of the project as to whether you can deal easily with these items because you've got records, or you can't. You're in a fog of uncertainty of where you stand. And therefore, I take away from what you've been saying from a legal perspective as a practitioner, as from a project management point of view, and someone putting together claims, is that the records are king. From having the right contract as a record with the appropriate provisions in it, through to all the subsequent post-contract documents like schedules and other records and progress reports and so on and so forth. If we're going to be successful and avoid being a further subject of an Arcadis report on badly prepared claims. So it's a lot of work. It's quite a big investment to do it, I think, from my perspective. But when we look at the costs of being late, the direct costs, and the other costs of liquidated damages or penalties for being late, then that investment is worth it. Because it's a major issue, is this, and it needs to be understood. So we hope that you've enjoyed listening to this podcast. And again, if you've any questions, contact us via LinkedIn, Alex Johnson or John Fotherby, and we'll be happy to address any questions or points that you have. And we look forward to seeing you in the next podcast, which carries on from this and deals with the simple subject of liquidated damages and penalties. We look forward to seeing you.